Good morning. It's a great day and new year here at Elville Associates, and welcome to our webinar series. A very happy new year to you and yours. What better way to start off a new year than getting back to the essentials? And that's what we'll be doing here today with today's topic, the essentials of estate planning and elder law, presented by Elville Associates Managing Principal and Lead Attorney Stephen Elville. My name is Jeff Stauffer, Community Relations Director with Elville Associates, and I'll be your moderator for today. You're in the right place for high-level legal education, and we encourage your general questions today. So please note them in the questions panel on your screen, and we'll pause periodically to address them. As always, your questions add value. They help others learn, so don't be shy in posing your questions at any time. You also received the presentation slides by email from me yesterday that Steve will be referencing throughout the presentation. Take notes on them if you wish. And these materials are also available in the section marked handouts on your screen to download at this time. For our professionals on today's webinar, a warm welcome to you as well. 1.5 continuing education hours are available for most everyone in attendance. So if you'd like to submit an ID number and your accreditation to me to provide a certificate of attendance, or submit your information to the CFP Board of Standards, I'm very happy to do so and can get that accomplished for you tomorrow if you'd like to provide the information to me. Everyone will also receive a post-webinar feedback email right after the presentation, so please take just a couple minutes to fill out this very brief survey and offer us your feedback about today's presentation. And we read and value every comment that you have to share with us. We have several new presentations coming up in February and March that are a direct result of the comments that you've shared with us in the past. And here at Elville Associates, we are always here as a resource for your family and you. Any planning that needs to be addressed, old documents that may need to be reviewed, or perhaps another matter, Steve and our team are here to help. Consultations are by far the most ideal way to get your specific questions answered, have Steve understand your specific situation, and offer solutions and a path forward for you. So today, relax, listen, learn, enjoy, and take action today. I'd like to offer Steve and the firm a proper and brief introduction before we get started. So you should be able to see my screen here. I adjusted the colors a little bit. I'm not crazy about them. I think I'll change them back. Elville Associates, we were founded in 2010 in Columbia by Managing Principal and Lead Attorney Stephen Elville. We have several different practice areas that we focus on here at the firm, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, tax planning and asset protection. We have 9 attorneys, 12 staff members, and 5 locations. Steve and I are coming to you live from the Columbia Gateway Community location today. Our mission, as it always has been and always will be going into 2024, is to provide practical solutions to our clients' needs through counseling, client education, and the use of superior legal technical knowledge. We focus on education a lot here at Elville Associates through several ways, through our planning processes with our clients, through educational webinars and workshops in the communities that we serve each year, and also by way of our accredited client care program. We're one of only 2 firms in Maryland to have a client care program accredited by the Client Care Academy in Boston. And we have our first quarterly CCP event coming up on January 20th for our members and new members. We're looking forward to that. We also work with the ideals of client education, collaboration, and compassion in mind with every client every day here at Elville and Associates. Just a bit about Steve. His work as an attorney for the past 23 years has been centered in elder law, special needs planning, and estate planning, with an emphasis in the areas of tax planning and asset protection. A member of many different national membership organizations, including the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys, along with Wealth Counsel and Elder Counsel. He works to bring peace of mind to clients by creating solutions to their needs through counseling, client education, and again, the use of leading edge legal technical knowledge. A very seasoned speaker, if you haven't heard Steve present before, offering many webinars, workshops for businesses and their employees, conferences, and continuing education events each year. Steve was also named to the Maryland Super Lawyers list for a 9th time and 8th consecutive year in 2024. So congratulations there, Steve. He also had a feature story written about him in a National Super Lawyers magazine about the Elville Center for the Creative Arts, our firm's charitable organization he founded in 2014, celebrating our 10th year this year. And I'm very privileged to be the executive director of. So if you'd like to learn how we work to make a musical difference in the lives of children each day, I'd be very happy to share our story with you when we have just a bit more time. Today we're focusing on the essentials of estate planning though, and we have a brief poll that I'm going to share with you to get us started today. And that very basic poll is, what brings you to today's webinar on January 3rd of 2024? What has made you decide to spend an hour and 13 minutes with us today and listen to Steve? And your choices are, first, I am new to estate planning and need to get started. Second, I have a plan in place, but it is outdated and needs updating. Third, I feel my plan is on solid ground, but education is always great. And fourth, I'm an advisor here to learn to better serve my clients. So make the choice that best suits your situation, so Steve can get an idea of who we have here today. Really hope you had a wonderful holiday. Always my favorite time of year. It's kind of tough when it's over though, but I'm really happy to get started with the year. I'm very excited for what it's going to bring. I'm very positive, very hopeful, very grateful as well. We'll take another 10 seconds here. Okay. We have 38% that say, I am new to estate planning and need to get started. 35% say, I have a plan in place, but it is outdated and needs updating. That is not out of the norm. 12% say, I feel my plan is on solid ground, but education is always great. And 18% say, I'm an advisor here to learn to better serve my clients. So whatever brings you here today, welcome one and all. Go ahead and close that out. Steve, I'll make you the presenter here.
Thank you, Jeff.
My pleasure.
Thank you for that wonderful introduction. And good morning, everyone. I'm going to show my screen and get my slideshow started. And first of all, can you believe it's 2024? And this is our first educational webinar of the year. I'm privileged to be with you. I could not do what I do here at Elville & Associates without Jeff, without our attorneys, without our staff, and without you and your support of our webinar series and all of our clients and past clients. And welcome also to our advisors and CPAs, without whom we would not have referral partners and someone to collaborate with and work towards the higher and best interests of our clients. So welcome one and all, and Happy New Year. And Jeff, how many years have we been doing this now? Probably over 10 years, I think, well over 10 years. And you know, I'm just so privileged to work with you and bring this information. For you who have not attended our webinars ever in the past, Jeff is a wonderful moderator, and he will stop as we go through the webinar at key points. If you have a question, you're to feel free to message Jeff through the chat and let him know that you have a question. We will stop occasionally. And the whole purpose of this workshop is to get you started with what we might call the fast start to the new year in 2024. I'm thrilled in a way to, you know, for your honesty and letting me know that maybe almost 70% of you either have no estate plan or you have an estate plan that is outdated and probably needs to be updated. So thank you for your honesty there. And today I want you to walk away with something substantive, something that you can hang your hat on and say, gosh, I got something out of this webinar that will help me not only become more educated, but help me to be able to move forward, to close the loop and get my estate planning in order, and then to understand some of the important concepts about keeping it updated over time. So again, I thank you and hope you had a wonderful holiday season. Jeff, just as a light note, it's only the 3rd, I guess, of January, but you don't have your holiday shopping done yet for next year, do you already?
No, I still have my tree up though.
Okay.
I did the hard decision of taking a lot of my decorations down, but
I gotcha. I just thought I would check in with you on that.
I did it with fond memories though.
All right. Well, thank you very much, Jeff, for checking in on that. All right. Well, back to our webinar, and welcome again. And it's a privilege to be here with you today. So thank you for taking your valuable time here on a Wednesday morning to really dig into this information. So we want to say that this is high-level information. This is not something that could be considered to be legal advice, but obviously we're going to do our very best to answer questions, even though they can't be construed as legal advice throughout the presentation. This is more of a high-level overview of concepts. And the one thing that I'm very proud of about this presentation is that most people who watch this will be able to honestly say that they know about 90% more than anybody they know about these particular issues, and also understand that this information is counterintuitive. This is not something you would be thinking about every day, and we don't want you to think about it every day, but we want you to be mindful of it. So that's what we're going to do, is walk through this, and occasionally I'm going to stop and use some time to give you some time to think, and that's one of the main purposes here. So if you have a tablet, if you have your phone, if you have a pad of paper in the old-fashioned way, whatever you're using, your computer, be aware that you might want to make some notes here and there as we go through. So we're going to talk about what estate planning actually is and what a process is for estate planning. And estate planning really should have a process. We have a broader webinar on that whole topic about how to achieve perfection in your planning, but we want to be aware of a process. We're going to talk about the possibility of estate plans that actually don't work the way they're supposed to, and how to avoid that. We want to talk about the basics of wills versus trusts, and these are some of the most common misconceptions or things that need to be clarified with clients and advisors. Elder law, taxation, and asset protection. Those are very broad topics, and what these mean today in today's planning, just to give you a very broad overview and a context from which to evaluate this information. And then we're going to give you an opportunity to move forward to either have your existing estate plan reviewed or to make an appointment to actually start new estate planning. So we're going to not only educate you, but we're going to give you a way to move forward today. So understanding estate planning is really understanding a process. And people plan for various reasons. And I'm going to give you a few bullet points here about why conventionally people do estate planning. But let's talk about some statistics first, just to show that estate planning is not easy. In one way, it is easy. All you have to do is step forward, let someone help you in an advisory capacity, like your estate planning attorney, like your financial advisors, like your CPAs, and potentially a life insurance specialist. That is a process that can be easy, but conceptually, it's a little bit difficult to get our minds around and to go through. And what we're going to do is give you that path forward to think through that difficult process, but having a reason to do it. Having a reason is really, really important, and having a process. So we're going to be talking about that. And I want you to start thinking about this. What is my plan, purpose, goal? What is my driving force right now? And we're going to take just a few seconds here as I go to the next slide that says, why am I planning? Do I want to provide certainty for my loved ones? Well, gosh, there's so much going on in the world. And Jeff alluded earlier about he was hopeful, which is wonderful. He's hopeful for this year. He's hopeful for, I'm assuming, a lot of things, and many of us are. We're hoping for a better world. We're hearing all kinds of negative things in the news. We've got all kinds of political and social upheaval. We're hoping that everything is going to be fine, and that ultimately our family and loved ones are going to be safe and well and healthy. And so we want to provide certainty. Smoothness of the administration for some people is a big deal. It's a big goal. Minimizing the cost of administration can be a big goal. Protecting assets, protecting spouses and children and grandchildren from the claims of creditors or divorcing spouses. Eliminating taxes. This is a key thing for many people, but the good news is it can be possible to eliminate estate tax today. Any kind of taxes that are affected by estate plans, we can talk through that, and we can figure out how to minimize those taxes. you might be a person that has a special purpose. Maybe it's a charitable cause. Maybe it's something that's near and dear to you, like a foundation you want to create. Maybe it's you have someone in your family who has special needs or disabilities, or a child or a grandchild who is challenged in some way. So we're going to talk about your definition of what your planning means to you. What is your purpose? And along those lines, I'd like to take about 60 seconds, and I've got my phone here, my timer, and I'm just going to hit the timer. And I want you to just be thinking, if you would, what is my driving force? What is my goal? What has brought me to this webinar today? Other than the fact that maybe we need to get some basic planning in place, but what is the underlying reason? What are my concerns, okay, as we enter into the new year? What are the loved ones I'm concerned about? What is there a business that you have that you're concerned about? Is it an aging parent or grandparent? What are the concerns that you have? Maybe there's a child or grandchild or niece or nephew who is at risk, and you want to protect their interest when you leave them assets. Whatever it may be, let's just take a few more seconds to jot that down. And Jeff, I'm actually going to give this a little bit more time here, maybe another 30 seconds or so. It's important to kind of have a frame of reference. And for those of you who don't really know right now what your goal is, you just kind of intuitively know you need to get some estate planning in place, and you know that you need to be educated about that, and your loved ones need to be educated about it. You kind of intuitively know this. So if you don't know, however, exactly what your goal is, that's one of the reasons we are here today, is to help you think through that, or in future meetings to help you have an epiphany as to what your goal or goals might actually be. And that's perfectly fine if you don't know what that is right now. Okay, I went a little bit longer than I promised, so we're going to stop that process, and hopefully you've been able to think through or write down some of your purposes or goals or reasons why you are here today and what you want to accomplish in your estate planning. Now, the reason that we have to be aware of the possibility of estate plans not working the way they should, which is a little bit of a new concept to some of you who have never seen this before. And why would I bring this up from the beginning, from the get-go, so to speak? Well, the reason we want to be mindful of this is because we're living in a fast-changing world. And we as human beings don't tend to react very well to our own estate planning needs. So when tax laws change, or people's health conditions change, or we have named this person to be our executor or our trustee or our agent under a financial power of attorney, but now that person is struggling, or they're no longer able to serve, or maybe they moved to another part of the world, we are sometimes slow to react. And some of us, when we're doing planning, don't really engage in a process that we're getting ready to talk about, a process that would actually be designed to make it much more favorable that your estate plan will end up working properly. So some of us don't get the chance to do that. Some of us are just not reacting very well to the fast-moving pace of the world. And so what we've got is a problem with updating. So most estate plans fail because people don't tend to update for about 20 years at a time. And I promised earlier that I was going to go through some statistics, and I got a little sidetracked. So let's go through those statistics now. Most people, and this will just put it into context, what I'm trying to say here. Most people in this country, in the United States, have no planning at all, well over 55%, okay? And in some demographics, divorced individuals up to 60% plus have no planning. And then when we look at specific age groups, we see age groups as you know, approximately in their mid-40s. Most people, about 80% of people, have no estate plan. So we have a vast majority of people in the United States that have no planning at all. But then we have the people who are what I will call the conscientious people, the good people that we all want to be. We want to be a part of the group that actually does our estate planning. So these people tend to populate about 45% of the population. But of these people, through no fault of their own, let's say, just because of the process of life takes over, many of these people don't update the plan that they initially did, and they were very, very good to do that plan. They didn't update it for about 20 years at a time. So If we don't update our plan ever, or we don't update our plan for 20 years at a time, is it a possibility that our plan will just not be updated enough to work properly? And the answer is yes. So I want you to think for a second, do you know anyone like this? Do you know someone who maybe did planning? Maybe you did planning. Some of you who are on this webinar, to your credit, maybe did planning 20 years ago, 19 years ago, 18 years ago, and maybe you're coming back now to get it updated. So I salute you for that. But maybe we know people who just don't update very often, and they're at risk. They're at risk because we need to have our assets titled properly. We need to be aware of the new tax laws, such as the Secure Act, and we just need to make sure that we're updating our documents on a reasonable basis as the laws change and as our life changes. There are two types of estate planning in my view. Other estate planners may or may not agree with me on this, but this has been my experience. I was trained in the mode of having a traditional estate planning approach. And what that basically means is that when we are in the traditional model, there really is no education of the client. I was trained in this business many years ago to really provide an excellent service, but not really provide any education. And what happens with this over time, which I learned later, is that because there's no maintenance and updating, that the family never becomes educated, the client never becomes educated, and there's a great chance that the plan may not work ultimately. And there's no education of fiduciaries, trustees, agents, executors, personal representatives, and so forth. There's no ongoing touch with the client, and then there's a possibility of just basically the plan fades away. It may or may not work, especially with regard to the way assets are titled or beneficiary designated assets, how those assets are actually flowing. So to avoid that, I've learned over the years that there needs to be a process. And for those of you who are more interested in this, more particulars about this process, we have another webinar that we're happy to send to you, or you can wait till we put that webinar on again. But we want to at least have some kind of step-by-step process. And what I would just try to educate you on this morning is that when you engage in a process with a law firm that is willing to engage with you in a process, then we don't have that one-dimensional approach, which is the traditional plan. We want to have, I would just argue, an educational or caring for clients plan. We want to have a non-traditional plan. And that involves three major steps, although we could take many steps in this plan. We want to design and implement the plan. We want to maintain and update the plan over your lifetime. And you'll notice I'm intentionally being redundant here to emphasize that. And then when we pass away, hopefully many years from now, our plan, when it matures, will actually work the way we want it to work. So this educational process-driven planning, it really just has an emphasis on education, as I mentioned, a life process, maintenance and updating, and it incorporates the cost of planning. So many people are concerned about how much it costs. Well, the overall cost, meaning the cost of implementing the planning, maintaining the planning, and actually how much it's going to cost when we pass away, that's something that can be addressed in this kind of model. Let's talk about what estate planning is. So we know estate planning is needed. We know it's a process, or it should be a process. We know that most people are not offered this opportunity to be in a process-driven planning process, but we also want to have a purpose or a goal. But let's talk about what the basic definition of an estate plan is. Well, it's really about, when you look at this, it's really about disposing of or passing along your property the way you want to the persons or organizations of your choice at the lowest possible cost. So this is one very, very simple definition of estate planning, meaning this is just one fundamental way of looking at it. Disposing of or providing for the disposal of your property the way you want to the persons or organizations of your choice at the lowest possible cost. Now, I want you to kind of juxtapose that with your purpose or your goals or your needs or your concerns, okay, now we're starting to gain some momentum in your thinking about the possibilities and the application of estate planning. So these are thought stimulating things that I'm hoping you're writing down, or at least getting that feeling as we go along. Jeff, I'm assuming there's no questions yet, but if there is, please interrupt me. And if not, I'm going to keep going through the slides.
Steve, we do have one question.
Very good.
Question is, we have an irrevocable trust for my mother's house. She is 91 and lives in the house. Is she no longer eligible for property tax reduction?
Well, that's a great question, and it's going to depend on what kind of situation that trust is. I'm kind of intuiting that it might be a Medicaid related asset protection trust. But if a trust like that is done properly, it won't affect her property tax status, but that would require us to be able to look at the trust and really understand the particular situation to really give some kind of an opinion on that. But generally speaking, properly done, it should not affect her property tax status.
Okay, thank you.
Thank you, Jeff. All right, one of the biggest questions that people have in the United States about estate planning is, should I have a will or should I have a will substitute, which is a revocable trust? So let's try to delve into this a little bit, and we'll try to keep it light. But I want you to use these slides, which Jeff will provide for you if he hasn't already done so. I want you to use these slides as a reference, okay? And this is by no means an elaborate explanation of probate versus non-probate, but this is a bullet point, very quick summary of the process of probate. So we have to first look at what assets would be controlled by a will. And let me just give you a visual on this. This is an old-fashioned view of what a will plan looks like. And remember, in estate planning, sometimes we do want to be old-fashioned. We do want to be very grounded in our approach. So here we have a will structure. The will is the driving force, but you'll notice we have incapacity planning documents also with the will. But right now, we're just really focused on the will. So I'm going to go back to the prior slide. So a will, by its very nature, is subject to probate, but not all assets are subject to probate. So you won't be able to answer me directly, but I just want to ask you a few questions. I want to ask you about a certain kind of asset. So if I have an asset in my own name, it has no beneficiary on the account and it has no joint owner. So let's say I had a bank account, it was just in my name, no joint owner, no payable on death beneficiary. Would that go through probate? And the answer is yes, because it's in my own name, it has no joint owner, and it has no beneficiary. So it would go through probate. What if I had an IRA? And that IRA it's got a beneficiary designation form, but I never fill that out. I never fill that out, and now my IRA has no beneficiary. Would that IRA go through probate? And the answer is yes. Same question with a life insurance policy. That life insurance policy should avoid probate as long as I have a beneficiary. But if I don't, that life insurance policy will go through probate. So we have to just understand that certain assets will go through probate, certain assets will not. So when we're talking about a will is going to control assets that are, the person has no joint owner, no beneficiary, and it's in their sole name. Now, with a married couple, if they're a traditional couple and they have everything jointly titled except for their retirement assets or life insurance, at the first death, is there going to be a lot of probate? And the answer is no, because everything will pass to the survivor that is joint and so forth. So with a married couple, most of the time we don't have major probate until the death of the second person. So some states have more robust probate than others. Maryland's probate is pretty robust, whereas I understand in Virginia, the probate process is relatively much more simple than in Maryland. New York, DC, North Carolina, my understanding is that probate is rather robust. But back to this slide, the probate process is really just a process of public oversight. What assets are subject to probate? There has to be an opening of the estate. Generally speaking, unless it is a certain type of expedited estate. It has to have an inventory. Creditors can make claims, and there has to be an accounting. And generally speaking, this takes about 9 months. Now, the cost of probate will vary depending on the state. And I would just throw out, arguably, that the cost of probate, when we consider all of the allowable fees, is probably around 4% on average. Okay, so that's just a little bit of a primer. If we have a will, that will by its very nature will go through probate. Some people don't care about probate. Some other people do care about it and want to avoid probate. And probate is going to involve the assets that are subject to probate, assets that are in the person's own name with no joint owner and no beneficiary. So as we go to this next slide again, you'll notice again now this will is controlling that process. Is there probate if there is no will? And the answer is yes. If there is no will, there could still be probate. So what happens is, as many of you have heard, the laws of intestacy take over, and the state of Maryland or whatever other state you may live in at that time, that state's intestacy laws will dictate where the assets go by law. So even if we have no will, there can be probate. Now, some people prefer to avoid probate, and they will use an alternative to a will, a revocable living trust, or just some people would just call it a revocable trust. So a revocable trust sounds complicated. Some of you on this webinar do have revocable trusts already. And if you do, it may be time just to revisit it, to restate it or amend it, and also, just as important, to revisit whether the trust is actually funded. So a revocable trust is not a mysterious thing. It's just an alternative to a will. You can have a will or a will substitute or alternative. And the revocable trust has 2 steps. One of those steps is to just create the trust, just like you would create a will. And in a will plan, which I just want to go back very quickly, in a will plan, we have 2 things. We're creating the will, and we're making sure beneficiary designations are flowing properly to the proper beneficiaries. But in a revocable trust, in a revocable trust plan, as you'll see here, we have 2 steps as well, but these steps are different. We're going to create and design the revocable trust similar to a will. That's the first step. To become educated, to make the proper choices based on informed decisions. And then the second step is to fund this trust, to actually align your assets with the trust. So non-retirement assets, like a piece of real estate, that your residence, a second home, these types of real estate go into the revocable trust. They become owned by the trust or retitled. Retirement plans do not go into the trust. Those stay outside the trust. 401ks, IRAs, and so forth, 403bs do not get retitled in the trust. But back to the non-retirement assets, stocks, bonds, mutual funds, CDs, money market accounts, all checking and savings, these kinds of cash and investment accounts get retitled. Even savings bonds, US savings bonds, would get retitled in the name of the trust. So once we have a fully funded trust, we now have a trust that will actually work the way it's supposed to. Now, here at Elville & Associates, and I'm sure other law firms see this as well, we see people coming to our firm that have unfunded revocable trusts. So that's just going to cause issues. And you see here in this particular slide that there is a backup will that goes along with the revocable trust. And that is designed to really become the catch-all and make sure the assets end up back into the trust, even if they're not properly funded. But again, we talked about plan failure earlier, and we don't want to have a revocable trust that would actually not work as intended. We don't want to have a trust that would fail. So we want to have a fully funded trust, and that is to avoid probate. But the other reasons might have to do with certain goals that you have, that it's absolutely essential that that revocable trust has no aspect that will go through probate. So as I go back through the slides, we want to recognize that the revocable trust is a substitute for a will. It's a private document. It has to be funded or aligned. However, is a revocable trust magical? Does it protect from creditors? The answer is no. Does it provide any particular tax savings? The answer is no. Even though it can be structured to do tax planning, just like a will can, it doesn't in and of itself protect against creditors or taxes. The administration of the trust still has to happen. So when we pass away, that trust still has to be administered. And the cost of administration, if the trust is properly done, should be less. It should be much less than probate, because that asset was funded into the trust, or those assets were funded into the trust in advance. And therefore, the planning basically has been done in advance to make it streamlined for your beneficiaries or whatever other goal you may have. So we talked about the will. Here's the revocable trust again. Notice it still has those incapacity planning documents that go with it. And notice that it still has a will that goes with it because it has a backup system. But we don't want that backup system to really play much of a part. And we want this trust to be fully funded, including business interests. So if you have business interests such as LLCs, those should be assigned or in other ways moved into the trust. So we talked about wills versus trusts. Now let's talk about another form of passing assets along. So if I were to draw a diagram for you with 3 columns, I would say this first column is the will, what happens at probate. This column over here to the far right would be revocable living trust, and kind of the polar opposite of the will, avoiding probate while still leaving the assets through a planned technique. And then in the middle here, I would probably call this non-probate transfers. So as you look at this, many of you are going to look at this list and say, oh, I understand what that is. Joint ownership, beneficiary designations, life estate deeds, which is a type of deed leaving assets at death without probate, payable on death, and transferable on death. These are brokerage account designations and bank designations to avoid probate. These are very useful in and of themselves, but the argument is that the will or the revocable trust is ultimately what's going to give you the kind of control you're probably looking for to accomplish your goals. These particular devices or transfer devices are very useful, but in and of themselves, they don't represent a true estate plan because they don't provide for the alternative disposition of assets should events occur such as prior death. Let's say someone predeceases you. Let's say that, heaven forbid, someone is injured and becomes completely disabled right before your death, and you never changed your will or trust, and now they receive assets that they shouldn't receive. Well, if you use these kinds of one-dimensional transfer devices, then your plan does not have any contingent alternative flexibility. So it's this lack of flexibility that causes the vast majority of people not to use these as their sole means of transferring assets, and rather to use a will or a revocable trust. So we have to be aware of this. And the other thing we have to be aware of is we have to be cautious here about the way assets are transferred from the owner to the beneficiary. So look at this slide, and if you notice this, you'll see that this is a great will or trust that's been created, but you'll notice that the assets are not flowing properly through the will or trust. So this was something that a person cared about a great deal. And as I go to the next page, for example, you'll see this, that this person put a lot of time and effort. They became educated. They were in a partnership relationship with their planning team, which we'll talk about. But yet they never paid attention to the titling of their assets. So the key to estate planning is basically to understand how assets flow and to make sure that our will or trust is properly designed, number one, but that the assets are flowing through that will or trust the way that we intended, or that beneficiary designated assets are flowing properly to achieve the same thing. It is possible to have a great will or trust, but the assets to flow in ways that are not conducive to the plan, and now the plan does not work correctly. So that is one of the problems here that we're trying to illustrate. We want to plan, we want to design the documents, but we have to make sure that the assets are flowing And we would call that funding the plan or asset aligning the plan. So those two steps are generally the key steps in estate planning. Jeff, I'm going to stop just here because we're getting ready to go into a challenging subject that we're going to get through, which is the incapacity planning subject. Is there any questions or should I continue?
Please continue, Steve. No questions as of
Thank
right
you.
now.
All right, so as we're planning for what happens at our death with the will or revocable trust, we also want to plan for what happens during our life. And so it's not going to surprise you that it's not uncommon for us here at Elville and Associates to meet with clients that are in their 90s or even occasionally people that are over 100. So people are living a long time, and we want to understand these basic concepts of incapacity planning. It's counterintuitive, but one of the arguments in favor of the incapacity planning documents being considered the most important of all documents is the fact that it's in these incapacity planning documents that we can articulate flexibility. And in today's world, one of the biggest things I would argue is important in estate planning is building in flexibility for changing circumstances. And this is extremely important in the incapacity planning. So as we look at incapacity planning, we're looking at financial powers of attorney and the medical directives, okay, advanced medical directives. And all states have laws about these things. In Maryland, we have a statutory form, and also in advanced estate planning, we use a general power of attorney. The advanced medical directive comes in various forms. There are forms from the Attorney General of Maryland, which we recommend for its flexibility and its customization that can be done with it. But there's also the 5 wishes. There are other religious type forms. What we're going to learn here is that these forms are flexible. Now, arguably, and I'm going to go back one slide, arguably, the financial power of attorney, in the opinion of an attorney, of an estate planning attorney, the financial power of attorney is arguably the most important document of all the documents. Now, some of you may say, well, no, Steve, the advanced medical directive is important because I have certain health issues and I want to address those. And I agree with you 100%. All the documents are important. But conceptually, the financial power of attorney provides the flexibility in the planning that you might want to achieve, or in your particular situation, you may customize this form or forms to provide a certain amount of flexibility, but not a massive amount. But others of you will provide tremendous flexibility for your loved ones to be able to manage your affairs in the event of your incapacity. We're not going to spend a lot of time on these slides, but just be aware that the Maryland statutory power of attorney continues to evolve over time, and over time it is changing, and the new version does contain some more advanced powers. But traditionally speaking, this form is a simpler form than the general power of attorney that we actually recommend that is used in conjunction with this form. So part of power of attorney planning is to not only try to articulate and understand the powers, but to try to articulate how much flexibility you wish to give. But it's really understanding the difference between the statutory forms and the non-statutory forms, which is an educational process. So these slides are basically for your education only, and it will start to give you an idea of advanced powers that can be used in financial powers of attorney. Financial powers of attorney are going to vary in power depending on what your goals are. You should not just sign a generic set of powers of attorney without understanding the powers that you're giving to your agent. We also want to be aware of when the power starts. When do we want to give our agent the power? Is it effective immediately? Is it effective only upon my disability? And do we want to have storage or access of these powers of attorney immediately? Do we want to store them until such time as they are needed? Or do we want to make sure that our agents know where they are or have copies of them? These are the nuances that are kind of in the background of the major decisions. The advanced medical directive for some people is the most important of all the documents. Again, this comes in different varieties, and some of you may be surprised that this form is very informal. We notarize all of the advanced directives, but the state of Maryland doesn't even require an advanced directive to be notarized. But notice here just how much customization can be done. Your personal preferences can be added, your food choices, your entertainment choices, your visitation choices, when the power becomes effective, whether or not the agent's decision-making power is flexible, or whether your decisions are written in stone. This is the only thing that your loved ones or your agent will know about you other than what you have articulated to them during your lifetime. So we strongly recommend that you customize this form and that we take time to review it. Elville Associates is one of the only law firms I'm aware of that spends significant time focusing on these ancillary or incapacity planning documents, because we know the flexibility that these documents provide at a time of crisis. We also know that these are documents that many law firms do not educate clients on, and clients need to be informed about how much power to give and understand these powers so that they're protecting themselves against fraud and abuse, and also understanding the limitations of the forms and how they're actually applied during their lifetime. The medical order for life-sustaining treatment continues to proliferate in Maryland. It is required by law. It is an aspect of medical advice and not certainly legal advice, but our legal advice about this is to understand what MOLST is. In some states it's called POLST, but it's required in Maryland, and it's required under many circumstances when we are in a facility. You may want a MOLST form if you're a person who is aging and you are over 65 or 70. You may want a MOLST form depending on what your doctor's opinion is. It's just an important thing to understand and educate yourself and your loved ones about the difference between the Advanced Medical Directive and MOLST. And MOLST is a medical order. It's a doctor's order signed by a nurse practitioner or a physician. And this difference in healthcare decision-making is something that I think a good 15 or 20 minutes of counseling is in order about this, but also speak to your physician. And also be aware that, God forbid, if we go into a facility, under many circumstances, this is required, depending on what kind of facility you go into. So just be aware that this exists and that it is required in Maryland. Let's now switch subjects, and we've been talking about the fundamentals of the estate planning process, how that works, the importance of a process. We've talked about wills versus trusts in basic estate planning, and we've talked about basic incapacity planning. Now let's talk about the estate tax planning environment and some tax issues. Well, we're going to briefly go through this slide. We're living in an unprecedented time of estate tax exemptions. So here in 2024, the federal estate tax exemption is over 13 million. Last year it was 12,920,000, and it has just been ratcheted up for inflation. But in 2026, January 1st, we are anticipating a cutting in half of the exemption amounts, down to somewhere around 6.5 million to 6.8 million. The state estate tax exemption in Maryland is 5 million, and it is to be seen whether that will be reduced if the federal reduces in 2026. But we are living in this unprecedented time of high exemption amounts, and hopefully they will continue and not end in 2026, but they very well may end as per the current law. So these are unprecedented amounts. If you are a person of higher net worth, we want to examine this and see if there's any planning that needs to be done now before these exemption amounts go away. So portability, I want to go down to third from the bottom. Portability is the technique that has been around now for over 10 years that has to do with spouses and the ability of a surviving spouse to port or use the exemption amount of their deceased spouse. So if you are a couple, a typical couple where one person may die, their exemption amount can be used by the surviving spouse. So that is called portability. Maryland has portability as well. There are rules and limitations to it, but it is a simplification of the estate planning process. Some of you who have documents that are outdated and those documents need to be updated may not be aware of portability, and the documents that you have from years past could be simplified possibly depending on your situation because of the use of portability. and the fact that the federal government is making it easier, still not easy, but easier to do estate tax planning. Marital control is an issue that still can be designed into trusts and wills between spouses. For example, there can be control. With the first spouse who dies, there may be no desire for control. They leave everything outright to the survivor. Whereas another couple may say, well, asset protection and remarriage protection are very important to us. We're going to design further trusts for the survivor, and those trusts may be a marital trust or a non-marital trust, depending on the situation. And protection against remarriage can be built in. And also we need to be aware of Maryland law, for example, that allows a broader election from a surviving spouse called the new spousal elective share. So all of these things, among many other issues, continue to proliferate, including the Secure Act, the bill that came out in 2020 that has been updated a couple of times now, where we have to understand that when we leave IRAs to certain individuals, they are exempt, but many, many people are not exempt from the Secure Act. And many of you have heard about the 10-year rule, where IRAs that are inherited by certain beneficiaries, such as children that are healthy, the taxation will occur in 10 years. So many of you have heard about this, but these are some of the things that are happening in the estate planning environment. This following week, I'm going to go to the Heckerling Conference in Orlando, which is the annual estate planning conference there for the national estate planning interests of many law firms. And all of these issues are going to be talked about, and Elville and Associates will share that information that is learned in practice, at our own practice. So we are looking forward to getting that new information. Switching now to elder care and long-term care, many people ask the question, what is the difference between estate planning and elder care planning or elder law? Well, this is really just a question of planning for disability. In estate planning, as we talked about so far, we're planning for the disposition of assets. Who gets my tangible property? Who gets my specific gifts? Who gets my balance of an estate, which we call the residual estate? How am I leaving those assets, in trust or outright? And basically, who gets my assets if no one is living? Like, who is the remote beneficiary? These are the common questions in basic estate planning. But in elder care, and of course, in the first category, we're talking about tax minimization, estate tax issues, income tax issues. Well, in elder law, we're still concerned about those issues, but there's a greater emphasis on asset preservation for long-term care, which is a big issue for many of you. Flexibility. How do we build in flexibility, not only for fiduciary decisions, but about preserving assets for long-term care purposes? In elder care, we're concerned about divestment of assets. Should we divest assets in advance? Is there any logic to doing that? Is that going to further our goals? Or no, we don't want to divest assets in advance of an illness, because that's not what we want to do. We want to have control of our own assets. And it's possible, if a person's goal does involve divestment of assets, it's possible to do it in such a way that you can maintain a certain level of control rather than just making outright gifts. And this could be for veterans benefit planning. It could be for Medicaid planning, which in Maryland is called medical assistance. And so as we talk about kind of the brief state of the world for estate and estate tax planning, and then we talked about how that differs, or elder care, how that differs from that traditional mode. Now we're going to illustrate some of those concepts. So as we talk about asset protection now as part of the presentation, and I know that we're hitting you with a lot of information here today, but remember, this is a broad overview of what is available to you as a person who's thinking about doing planning or updating your planning. So asset protection is really where a lot of focus is today in planning. Some of you may not have a goal of asset protection, while others of you do have that goal. So as we look at asset protection, the only way that I can sensibly discuss this with you is to break it down, such a broad topic, to break it down into 3 categories. So I've always thought as asset protection as maybe the first category being the lifetime asset protection that you already enjoy. Some of you have this already, and you may not be aware that you have asset protection in certain things that you own. We're going to talk about that. We're going to talk about long-term care asset protection, which we were just mentioning a moment ago, about the divestment of assets and so forth. And then we're going to talk about how to provide asset protection for loved ones at your passing. And this is possibly, although it sounds counterintuitive, this is possibly the easiest thing of all to do. So as we look at lifetime asset protection, I apologize to the single people on the webinar today, but if you're married or you're thinking of becoming married, you can own property as tenants by the entireties, as spouses. And that tenants by the entireties label or umbrella over the policy, over the asset, it provides a certain layer of basic asset protection. So let's just say that the unbreakable whole, so the undividable whole of the asset, like a residence, if one of the spouses gets sued but the other one doesn't, then the asset cannot be torn in half. It's an undividable whole. Tenants by the entireties is very big in Maryland, very big in Delaware, and some states also, other than those two states. And we want to, conceptually own as many assets as possible as tenants by the entireties. And many of our financial advisor collaborative friends are continuing to increase their knowledge about this and help people own brokerage assets also as tenants by the entireties in many cases. Life insurance is protected in Maryland from the claims of creditors as long as the spouse or a child is a beneficiary. So that's an important thing to know, is that life insurance has an asset protection element. Annuities are also protected from creditors for the same reasons. Now, qualified plans and IRAs that you own these things: 401ks, IRAs, 403bs, 457 plans, SEP plans. These plans are protected from the claims of creditors, especially qualified plans. But when we die and we leave an IRA to someone as an inherited asset, such as leaving a child an IRA, that child is not protected from the claims of creditors anymore, based on a Supreme Court ruling several years ago. So we have to assume that when someone receives an inherited IRA, that they are not protected from creditors unless we leave that IRA in a trust. And that's going to pose a little bit of a problem now in light of the Secure Act, which says that a healthy child must take all of that IRA money out in 10 years. So that's a counseling issue about what we're going to do about that in your particular planning. Of course, there's 5 types of individuals that are exempt from the Secure Act, and we could hold assets in further trust for those particular beneficiaries. But even in those cases, sometimes we still have a problem with the taxation element of the Secure Act. So those things are all problems that have to be solved. But the basic idea is that we are not going to have asset protection in an inherited IRA for anybody who receives it outright. So we have to be careful about that. Domestic asset protection trusts. Maryland is not a domestic asset protection state, but our neighbors in Delaware are, and there's about 16 or to 19 states that call themselves asset protection states and have asset protection laws, such as South Dakota, Alaska, Wyoming, Nevada, and so forth. So we want to avail ourselves of these jurisdictions if we are trying to achieve asset protection on a broader scale, and that's going to be an advanced planning consideration. Now, asset protection in the long-term care context. So now we're moving into a different kind of asset protection. We talked about asset protection for Medicaid, and here we are seeing for the first time the name a Medicaid Asset Protection Trust. So arguably one of the most powerful tools in estate planning today, and in elder law certainly, is a Medicaid Asset Protection Trust, which is a hybrid irrevocable trust designed to protect assets from long-term care spend down. So this trust is the kind of trust that can be developed to give the grantor control. It has certain tax advantages. It has asset protection features, not only for long-term care, but protecting assets from the claims of beneficiary creditors, all while being able to make a gift to divest assets for Medicaid purposes. So this is a very powerful technique, and we're here to help you counsel through this kind of technique. Veterans Asset Protection Trust is a similar trust, but different, designed to help someone qualify for the veterans pension that is available. VA has many pensions actually, but this is the veterans aid and attendance benefit that many people are eligible for if you are a qualified veteran of a period of war. Use of trusts established under wills. So this is a technique where, let's say, heaven forbid, someone has a spouse who has a progressive illness or a dementia of some kind. This is a technique that can be used to protect assets in ways that are not invasive. With no divestment of assets, it can be structured in such a way that assets could be protected depending on which spouse dies first. So this is a very big planning technique. The augmented estate, this is a fancy way of saying that Maryland now has new laws that have to do with what is considered part of an estate. And this has to do with understanding many things related to elder care, but it also has to do with understanding the new spousal elective share that is allowed under the law. So as we think about how we leave our assets, or as we think about how we want to protect our assets from long-term care spend down, we have to understand this augmented estate concept and the new spousal elective share, which is beyond today's discussion. Crisis planning involves a 5-year divestment period, where in the old days, it used to be 3 years, excuse me. So if we divest assets 5 years in advance, we can put assets out of reach of a long-term care spend down. So this is a counseling issue. This is a goal-related issue because all planning is goal-driven. So someone whose goal is driven by this type of planning, we have to understand the pros and cons of doing this technique, but many people want to do this and are motivated by it. As long as they understand the pros and cons, we think it's a great idea. The rule of halves has to do with someone who doesn't divest assets in advance, but wants to save some of the assets because a crisis situation has occurred. And to make a long story short about the rule of halves, it is a wonderful technique that is still available to us to be able to preserve about 50% of any remaining assets if a person has to go into a long-term care skilled nursing facility. Unfortunately, the plan does not work in cases where a person is not in a skilled facility. And here in Maryland, we continue to be, unfortunately, one of the worst states in the country when it comes to paying for long-term care when a person is in assisted living or living at home. Maryland does pay for long-term care through its Medicaid program when someone is in skilled nursing. So this is one of the issues that is really missing in Maryland, is the ability for someone who can't really afford assisted living to really have some kind of assisted living benefit so they do not have to live in a nursing home. But I'm digressing, and I want to get back to the rule of halves. This is a powerful technique for someone who has not divested assets, but has provided for the flexibility. Remember back to the financial powers of attorney. You can provide this kind of flexibility in the financial powers of attorney to give your agent the ability to preserve assets under a crisis situation. The life estate deed comes in two forms, with or without power. If someone gives away their property in form of a life estate deed while retaining the right to live in the property, but they have the right to sell the property, that avoids probate. But if the person does the same technique and gives up the power to sell the property, that means that they are starting the 5-year period. So they can divest the asset without using a trust. And there are pros and cons to doing that. So that's what the life estate deed planning technique is. It can start the 5-year Medicaid period. And as we start to come to the end of this rather broad presentation, we're getting now to asset protection in the context of actually dying. So when we pass away, we can provide asset protection for spouses. Now, there is one exception to this. We can provide asset protection during lifetime for our spouses through the use of a marital trust that's created during life. But this slide is illustrating what happens at our death and what can we do if we wish to not keep it simple so much, but actually provide asset protection for our spouses or children. So we leave what we call spendthrift trusts, or what we might call spendthrift protected trusts at death. That's a fancy way of saying we can leave assets in a shell of protection for our loved ones. and they can be protected from divorce and the claims of creditors and bankruptcy and car accidents and so forth. These trusts do not protect all circumstances because the government, Uncle Sam, and our public policy have exceptions such as alimony or child support or the IRS or the Comptroller of Maryland. But generally speaking, these spendthrift protected trusts do protect our loved ones when it's most needed. And these have to do with structuring trustees, the use of special fiduciaries like a trust protector, the use of powers of appointment. These are all techniques. And of course, our special needs loved ones and beneficiaries must be protected in many instances with special needs trusts. And these are a form of protected trust as well. So leaving assets at death and protecting the shares of spouses, children, grandchildren, nieces and nephews, and others, this can be done through these techniques at death. Now, trust can also be established during life, as I mentioned, but in this particular context, we're just illustrating the various types of asset protection, and I hope that gave you a general overview. As I mentioned, the Secure Act came out in 2020. It was supported by both sides of Congress, and we see no end of the Secure Act in sight. This means that, unfortunately, even though many people now are going to be able to save for retirement through the Secure Act and its broad provisions, the Secure Act basically took away the stretch IRA, the ability for you and I to leave an IRA to our loved ones, with some exceptions, to leave it to our loved ones where they can stretch out the taxation until old age if they don't need the money. Well, that's a thing of the past unless you meet one of the 5 exceptions. You are a spouse, you are someone who is less than 10 years younger than the beneficiary, you are a minor, and minors for Secure Act purposes are defined as someone who is under 21 years old, or you are a chronically ill person, or you are a person with disabilities that has special needs. And for chronically and disabled people, the Special Needs Trust is exempt as well. So those 5 types of individuals can stretch out their IRA required minimum distributions the way we always could. But now the Secure Act has limited that and said anyone who is truly healthy and is not a spouse, unless they're less than 10 years younger, they only have 10 years to take out that money. That means that Uncle Sam is going to tax trillions of dollars on a very accelerated basis. So we need to have all plans basically reviewed and getting our minds around what is the effect of the Secure Act with regard to our retirement plans. And whether or not we should buy life insurance as a wealth transfer tool because we're going to have that accelerated taxation, or whether you should try to endeavor to do some Roth conversion during your life and kind of beat Uncle Sam at this game by making sure that all your IRAs are Roth converted if that is the appropriate thing for you over time. So with that said, I'm going to continue now and talk to you just in closing about our client care program. And Elville & Associates is one of the only firms in this country among a handful of firms to have a client care program. And we are one of the only firms in Maryland to have a client care program. And we're very proud of this program. What it does is it encourages you and it encourages us to be in a partnership together to continually update and to also educate you and your loved ones. For example, when Elville & Associates does an estate plan, we always like to have a family meeting, if it's appropriate for, and it is for most families, to actually put the plan in place, but also have a family meeting of about an hour and 15 minutes to really go over the plan, to make sure that all the fiduciaries, the trusted people that are going to be in charge of the plan, understand its concept, understand what their responsibilities are, understand where the resources are to them if something happens, and where we are or where the other resources are that they can get a hold of and get in touch with. So when we have a partnership relationship and a client care program, the chances of the success of the plan go way up. So the client care program is not required for you to be a client of Elville & Associates, but we strongly recommend that you consider participation in the client program, care program. And we have 4 events a year, including a social event. And we put on educational events for you and your family to be able to learn and to get on the leading edge of many of the concepts. And it also includes annual updating and biannual updating. of estate plans so that we are on top of that process as life continues to drag us forward with so many distractions and so many things happening in the world. So we just want you to know about this client care program. Jeff has more information about it, but all of this goes back to the concept that we talked about at the beginning. As I continue to scroll through, you'll be able to see this when you have your own set of these slides. So this all goes back to this concept that we talked about in the beginning of the different ways that estate planning is done. And we don't want typically the traditional approach. We don't want that very quick, traditional, one-dimensional approach. The way we do that is we kind of say we're going to commit from the very beginning to consult and completely educate with one another, and to really go through things in a very caring way and a very hand-holding way, and to give you the time to think, which I'm going to cover here as we wrap up. So we encourage you not to just be educated, but to also set a consultation with us. There's no consultation fee unless we are talking about an urgent elder care issue. We want you to fill out an estate planning questionnaire. This is a big step, but the estate planning questionnaire is arguably one of the most important things in estate planning, because that's the basis that we all get started on together as we work together. And it's a lot of information. It's a lot of personal information that you're sharing with people you have not necessarily met before. So we want you to understand that that's okay, and here's why there's nothing to fear. There's nothing to fear because when you consult with an estate planning attorney, such as Elville and Associates, we are under an attorney-client privilege situation, and everything is confidential. So everything you say and share with us is confidential, even if you do not become a client. So just remember that it is a confidential relationship, and ethically we are obligated to have that attorney-client relationship with you, even if it's just a consultation. We would like to see your current estate planning documents, so please bring those. We'd like to briefly review them, and we don't charge generally to review estate planning documents that you currently have. So that's one of the things we want to do. We want to help you have an advisory team. We know that there are probably advisors and CPAs on this webinar, but you as individuals who are thinking about estate planning or updating your estate planning, we want to make sure that you are satisfied with your advisory team, or you may not have one. You may not have a CPA, a financial advisor, a life insurance specialist, or if you have an elder care issue, you may not have a life care manager that you need to be there and advise you in very important ways. So we want to help you form an advisory team if you do not have one, and we want to collaborate with your advisory team and communicate. This is one of the keys to making planning work. We want you to come in with questions. We didn't have a lot of questions today during the webinar, but that's fine. We may have some questions coming up here at the end. But moreover, we want to give you the time to think. Several years ago, especially right after COVID started, when Jeff and I would do webinars together, we decided that one of the most important things that we could do is give clients the time to think, the time to sit and be educated, the time to think outside of the busy world outside, and really get down to what is the goal, what are the epiphanies I'm having about my planning, what are the choices that are available to me today. And I know many of you know exactly what you want, but we want to make you aware of what your options are. And that's our goal, is to be counselors and to actually give you the time and space to think and to develop your own thinking about your plan in a partnership path. So with that said, I really thank you for sitting through all of this morning. Jeff, I think we're basically right on time. And I appreciate everybody just really sitting through that and absorbing it. And I hope a lot of notes were made and a lot of epiphanies were maybe gathered right here today, this morning. And I'm going to wrap it up, Jeff, and let you take over and see if there's any questions, but just thank everybody, including you, Jeff. Thank you.
Well, thank you, Steve. A lot of great information, as always, very comprehensive and great start to the year, going back to the essentials as always. So now would be your time to get any questions that you have in for Steve. So I'll say, as we wait for those questions, our webinar series continues forward. as we head into January. So January 9th at 10 o'clock, we have a new presentation offered by our senior principal and senior elder law attorney, Lindsay Moss. Probate, what is it and how can it be avoided? January 9th at 10 o'clock. January 17th, always one of our more well-attended and important presentations, what families need to know about planning for a loved one with special needs. January 17th at 10 o'clock, offered by Steve Elville. And for those interested in an evening presentation, on January 23rd, we'll be coming back to this same presentation. On January 23rd at 7 o'clock, the essentials of estate planning and elder law. So if you want to come back and see us again, or have family members or friends that couldn't be here today in the morning, but want to come back and see us in the evening, that's at 7 o'clock on the 23rd. And we have our advisors forum coming up in February for our advisor friends that are here today, and we'll have more about that very soon. And I look forward to seeing you all again soon. And I'll have the video and a comprehensive email with some of the resources that Steve talked about as well coming out to you first thing tomorrow morning. So with all that said, do we have any further questions? Looks like we don't. Steve, we had a reflective audience today. And that's
Well, you
good.
know, Jeff, everybody's just probably getting started in the new year, and
That's right.
probably felt like I did yesterday. So that's perfectly fine.
So we appreciate you being here today. Always want to be a resource to you, as you know, and I look forward to seeing you again on another edition of the Elville webinar series. Have a great day and rest of the week, and we'll see you again soon.